Good morning, everyone. Welcome to the Thursday, January 30th, 2025 agenda meeting of the Minnesota Public Utilities Commission. I'm Katie Sieben. I'll take the role of the other commissioners who are present for today's hearing. Commissioner Hom.
Here.
Commissioner Sullivan.
Here.
Commissioner Tuma.
Here.
A quorum is present. We have 3 items on our agenda today, and our first item will be introduced by Mr. Warbla. When you're ready, please.
Madam Chair and Commissioners, item number 1 is docket number E002 M23454 in the matter of Xcel Energy's petition for approval of its 2024 Renewable Energy Standard Rider revenue requirements. The question before the Commission is, should the Commission approve Xcel Energy's 2024 Renewable Energy Standard Rider revenue requirements? Staff also understand that Xcel would like to add some clarification on decision option number 5.
Okay, if the parties could please come forward. We'll start with appearances, and if someone's here for the department or maybe online too. Mr. Conlon, please state your appearance.
Good morning, Madam Chair, Commissioners. Riley Conlon on behalf of Xcel Energy. I also have with me Mr. Ben Halama and Ms. Laura Brennan is on WebEx.
And sorry, who was the last person? I couldn't hear.
Brennan.
And Dr. Lieb, welcome.
Morning, Sydney Lieb on behalf of the department, and I have Mark Johnson and Mary Beth Carwald online.
Okay. It seems like most of the issues here are resolved in terms of the decision options, but we'll hear about, or if we could just start with your thoughts, Mr. Conlon, that you wanted to share on decision option 5, and then also Commissioner Tuma's alternative decision option as well.
Thank you, Madam Chair. As you said, we have a slight clarification to decision option 5, and we would propose to simply add clarifying language to the end that states and rate base impacts. This clarification is consistent with, or we believe consistent with the department's August 8th, 2024 reply comments to fully capture what we're including in that benefit analysis.
So it would say to calculate the benefit, Xcel must use the portion of any deferred tax asset refund in the May 31st net operating loss compliance filings and what?
And rate base impacts.
Any objection to that, Dr. Lieb? No.
No, Chair Sieben, Commissioners, the department supports the amendment.
Okay. And we can turn to Commissioner Tuma for his alternative decision option next. Commissioner Tuma?
Yeah, Madam Chair, I was just trying to read between the lines, which my family will tell you I'm not the best at doing all the time, and understand what your agreement was and try to memorialize it if we're going to change, or are changing and have it changed already, the depreciation lives for Northern Wind and Rock Aetna. So I look to you. I don't know if I hit it or if I missed it. So
Who's that for?
either one.
Okay.
I want to know there's a meeting of the minds and it works. So
Mr. Conlon, did you have thoughts first?
Thank you, Madam Chair, Commissioners. We view Commissioner Tuma's decision option 2 as a helpful clarification to briefing papers. But I can also confirm that the depreciation reductions for 2023 and 24 are already reflected in the 2025 res filing. Therefore, it may not necessarily be needed, but we absolutely do not oppose it.
and it was not my understanding. You're implementing the change as of this year, so it's already implemented because we're past January 1. But what was confusing to me was what do we do with those 2 prior years? How is that reflected? But you're saying that's already reflected in what you've done. And if there's adjustment to be made, we would do that at the true-up time.
Madam Chair, Commissioner Tuma, that is my understanding, correct?
So the depreciation has started theoretically from 2023, but, and you've already accounted for that in the 2025 filing, and you'll true it up if there is any true-up. That's what I was trying to say, so.
Correct, Madam Chair, Commissioner Tuma, I believe that is all in the chart.
We're not talking about a ton of money here, we're just on the margin.
Mr.
Dr. Lieb, am I
sorry.
tracking with you?
Chair Sieben, Commissioner Tuma, that's exactly our understanding, is that it's already done, but we're happy to adopt your alternative decision option if it's helpful as a clarification.
Well, I thought we should memorialize the fact that they've agreed to extend the, the life. That really wasn't clear to me, and the order should state.
Yeah.
We're agreeing to, and we're okay with this extension of the life for these 2 facilities, so.
I have a question about the battery storage project, Mr. Conlon. I thought that normally projects don't go into the res until they're in service, but I understand that there's, a little ambiguity perhaps with construction well in progress. So can you just talk me through the company's perspective on why the battery storage project is eligible for the res now before it's in service?
Thank you, Madam Chair. Yes, and so our understanding of the RES statute, which is 216B, 1645, subdivision 2A, is that it allows for recovery of projects once they are approved or certified, whether it's resource planning, but approved in the proceedings outlined in the RES statute. We have a long history of projects once approved or certified to be flowed through the RES. And so I believe it's docket number, is it 22119? 23119 was the Form Energy Battery docket. And so since that was approved, and then there is subsequent language in 216B16, which is the automatic adjustment language, I believe it's subdivision 7. We in that proceeding had noted that rather than create a separate rider for the Form Energy Battery project, we would flow that through the res as well.
Okay, I'm not objecting or saying that it shouldn't go through the res eventually. It's just this question of timing that I think is a little, that I just wanted to make sure everybody was comfortable with. Dr. Lieb, any thoughts from you or Mr. Johnson on this topic?
Chair Sieben, the department is fine with the interpretation of the res rider requirements that the company is taking, and we don't have any concerns with the battery storage costs at this time.
Or starting, it's not the cost, it's just starting them into the rider now. Okay, that's good. And then my other question is for the company first, and then the department, if they have any thoughts to add to this. There's been discussion federally from the new Trump administration that they are potentially going to try to roll back the production tax credit. And we see in this docket, in really explicit dollars, how the PTC benefits ratepayers. Do you have any updates or thoughts about any actions you've seen or correspondence that also causes the company to be concerned about a potential federal rollback of the PTCs? And then my second question is, would you be opposed to a compliance filing if anything does change in this docket? So you're notifying us immediately of any changes that you think would impact the PTCs.
Madam Chair, thank you for the question and certainly appreciate it. I want to make clear that the company is closely and carefully monitoring changes at the federal level at this time. That said, it's too soon for us to definitively identify if there are any impacts to matters in this proceeding. Consistent with that careful monitoring and observation, we can commit to providing updates as appropriate, absolutely.
Okay, and I think that was my understanding, is nothing now would impact this docket, but I'm just concerned that the direction and some of the language, it could have a real substantial impact on the costs that ratepayers pay for these projects. Dr. Lieb, anything you wanted to add on this topic?
Chair Sieben, the department's understanding of current federal rules are that the executive branch cannot roll back the production tax credit without action by Congress. It cannot be done by executive order. And there's been no suggestion at this time that anything would be changed on the tax credit side of the Biden environmental policy implementation. We would support if you want to require the company to put a compliance filing should anything change, but it would be a substantial overstep of executive branch power if they were to try to change that.
Good. So, Mr. Conlon, then if we ordered you to notify the commission, like immediately in this docket, of any federal changes that impact production tax credits, is that, or the investment tax credits, that you'd be okay with that?
Madam Chair, absolutely.
Okay. Good deal. Any other questions from commissioners? Commissioner Tuma, did you want to make a motion that, and then I think we can just rely on Lana to swoop up what I said.
So I would move decision option 1, Tuma alternative decision option 2, 3, 4, 5, as amended by Xcel to include and rate-based impacts, I think was. You got that, Lana, right? Good. And number 6, and then also the compliance filing for any changes to the PTCs,
And ITCs.
ITCs. That'd be my motion, Madam Chair.
Is there any discussion? All in favor, please say aye.
Aye.
Aye. Opposed, the motion passes 4-0. Thank you, everyone.
You're like 3-0 now, aren't you? Maybe way off. Sorry, Ron.
They gotta give them another, more difficult one, maybe a CSG one or something like that. I think Mr. Dennison would be happy to give you a CSG.
He's trying not to laugh.
Next is item number 2. Ms. McShane, please introduce it for us.
Good morning, Chair Sieben and Commissioners. Item number 2 is docket number G002/M22257 in the matter of Xcel Energy's 2021 Gas Affordability Program Evaluation Report. The question before the Commission today is, should the Commission approve Xcel Energy's November 21st, 2024 proposal to adjust its Gas Affordability Program, or GAP, surcharge and budget? On Tuesday, staff filed a new decision option 4. Yesterday, Xcel Energy filed an alternative decision option 4. Both have been provided to commissioners, and hard copies are available at the front of the room. I have no additional comments, but I am available for questions. Thank you.
Okay, thank you. If the parties could please come forward. We'll start with appearances on my right, Ms. Steinhauser.
Good morning. Lauren Steinhauser on behalf of Xcel Energy.
Good morning, Sydney Lieb on behalf of the Minnesota Department of Commerce, and I have Michael Zychek online.
Good morning, Madam Chair, Commissioners. Brandon Crawford with the Citizens Utility Board of Minnesota.
Good morning, Madam Chair. George Shardlow with the Energy Sense Coalition. Okay,
great. First, I'll start with the staff new decision option 4, and I looked over your alternative to 4, and it seems like a good clarification. The discussion is not dissimilar to the one that happened in the last docket, where there's a concern that federal funding for LIHEAP could be that a remaining 10% might not come to states. And then we were discussing in my briefing what would happen then to how the GAP statute is tied to that receiving of federal assistance. And so I assume, Ms. Steinhauser, that your Xcel alternative 4 would essentially still allow then, should that payment be discontinued, you would still be able to administer the GAP funding as outlined in the docket.
Thank you, Chair Sieben, for the question. That is correct. We would continue to offer or to provide the GAP funding to those folks who have received GAP credits in that federal fiscal year 2024.
Mm-hmm. And the department, do you have any concerns with this then, and do you support it?
The department supports either the staff decision option alternative or Xcel's. I think we slightly prefer the staff's because it doesn't have the same timing constraints, but we're supportive of and understand the companies wanting to put a little bit more timing.
Sorry, I didn't look at it enough to know what the difference is. So can you just help me understand a little more, Dr. Lieb?
The Xcel's specifying the fiscal year for 2024 versus the staff one is any time in 2024.
Mm-hmm.
So it seems the company's 2024 fiscal year might be a shorter period of time, unless we're misunderstanding.
Ms. Steinhauser.
Thank you, Chair Sieben. So the federal fiscal year runs from October 1st to September 30th. So my understanding is federal fiscal year 2024 would be October 1st, 2023 through September 30th, 2024. And the reason for that clarification is that LIHEAP funding is received on the federal fiscal year, so it aligns with our enrollment and record keeping for the program.
Dr. Lieb.
Thank you, Commissioner Sieben. So I think the question the department has then, would we have to come to a new order for fiscal year 2025 coverage if LIHEAP was cut off by the federal government completely?
Ms. Steinhauser.
So my understanding of how we would plan to implement this is for any customer who received credits in that federal fiscal year 2024 would continue to receive GAP funding unless and until we come back before October 1st. If something were to happen and we need to adjust enrollment, then we would work on a proposal with the stakeholders and with the commission to do that. Mm-hmm. So this would be just to fill that gap, no pun intended, for that period.
Mr. Shardlow, please.
Not to belabor the point, but on a practical level, part of what may have happened is that someone may have been approved for LIHEAP in November 2023, and as a result, the auto-enrollment that we did in July 24 was for all LIHEAP recipients for the FY24 heating season. So it's just, from our perspective, going back to October 1 is accommodating that potential individual who got approved in November for LIHEAP and then got enrolled in GAP in July 24.
So, Mr. Shardlow, did I hear then you are supportive of Xcel Alternative 4?
Yes.
Okay. And Dr. Lieb, with that further understanding, are you too?
Commissioner Sieben, yes, thank you for the explanation on the timeline there. I think the department's fine with that, as long as there's a scheduled time to come in and make sure. I assume this is an annual filing, and we would reassess next year.
This docket is an annual filing, is it not, Ms. McShane?
There is an annual filing. It's not in this docket. It is a annual docket, so it would be, it would come in May, or is it? No, I think it's March 1st.
And what is should we reference that docket then, you think?
Yep, I can pull it.
Okay, well, and Ms. Steinhauser, any thoughts on that?
Thank you, Chair Stephen. I believe it's April 1st, but the thought with providing the date in our alternative was we'll be coming to the commission with an update on April 1st, and then if anything were to change between April and October, we would, of course, keep the commission informed.
Okay, and is that all contained in your alternative 4, or we need to add more language?
The annual filing is not, because that'll happen regardless, but the October 1st date to come back with any other changes is in our alternative.
Okay. Does that, I see some thumbs up. On the other issues in the docket, Commissioner questions, Commissioner Tuma?
Yeah, really quick, Ms. Steinhauser, on page 2, they note that all the rate adjustments are going to start February 1. Is that still the plan? I didn't read your petition, so I don't know if there's a contingency if we didn't give you an order in time, but I suppose you could have it already teed up. So is it going to go into effect on February 1, or is there a different date?
Chair Stephen, Commissioner Tuma, the change does require a tariff modification, so my understanding is that we need an order in order to implement the tariff modifications that would then put this in place. So it's unlikely that we'll be able to do it by February 1st. The hope would be March 1st if that would work. And then from there, we monitor the tracker monthly. And so to the extent that impacted the tracker balance down the line, we would inform the commission of that with our annual filing on April 1st.
And does your, again, we say February 1st, but does your petition say within so many days of the order, or what? We're approving your petition, not a date. So what does your petition contemplate after the order is issued?
The petition contemplated getting the tariff modifications in place by February 1st.
So there was no contingency, or within 15 days of the order, or anything like that?
Correct. No, the petition didn't contemplate that contingency.
We need to do that, or is that something we just trust that you're going to do anyways because you need to get the money flowing?
Commissioner Tuma, we implement new rates on the 1st of the month, so it's either February 1st or March 1st or April 1st is how that works.
So there's no really need to say that in the order. We just know that is going to be the case.
That's correct.
And Ms. Steinhauser, do you, I was pleased to see the increase in gap enrollment and the automatic enrollment obviously is working because we're seeing more customers in it. Any, and maybe it was covered and I just missed it, but the overall impact to helping customers, or how many people will receive this funding now and how it will help decrease arrearages. Can you just remind the commission of that?
Thank you, Chair Stephen. James Fjorden is here with me, who has the details of the program, if you can join me.
I kind of put you on the spot, sir, too, so if you have just other, specifics about number of people it will help, or how it will help decrease arrearages, which we know is a problem right now, would be helpful. And please state your name for the record.
Absolutely. James Fjord, I'm a supervisor for our personal accounts organization. What we are anticipating is with the auto enrollment and the increases, we would see roughly up to 18,000 customers or so throughout the year at some point enrolled in our GAP program.
That's great. For Energy Sense, anything that you wanted to add that, I know you're supportive of the change, but thanks for your continued work on this matter, and Any other comments you'd like to make for us before we vote?
No, as Mr. Jordan alluded to, it's been a very effective way to draw more people into the program, and it's powerful and needed relief.
Great. Any other discussion? Otherwise, I can move decision option 1, 2, 3, and Xcel alternative 4. Any discussion on my motion? All those in favor, please say aye. Aye. Opposed? The motion prevails. Thank you. Ms. McShane, please introduce item number 3.
Item number 3 is docket number E002/M21695, and the matter of tariff revisions updating community solar garden tariff, providing additional consumer protections to subscription eligibility. The question before the Commission today is, what actions should the Commission take to address tariff revisions to provide customer protections to tenants under a rebilling or third-party billing arrangement? Commissioner Tuma filed a new decision option 5 on Tuesday. It has been provided to commissioners, and hard copies are available at the side of the room. I have no more comments, but I am available for questions. Thank you.
Okay, if the parties could please come forward. Mr. Teglin, starting with you, please state your appearance for the record.
Thank you, Chair Sieben. This is Peter Teglin for the Minnesota Department of Commerce.
Thank you, Chair. Jim Dennison on behalf of Xcel Energy.
Good morning, Peter Schultz on behalf of the Residential Utilities Division at the Office of the Attorney General.
George Hardlow, Energy Sense Coalition.
Morning, Chair Brian Edstrom with the Citizens Utility Board of Minnesota.
We're just taking a mini pause here.
Good morning.
I think we're having a little bit of trouble with the system. It's good? We're still good? Is there anyone online, too, that's appearing? That you could turn your camera on and state your name for the record?
Good morning, Chair and Commissioners. Gary Van Winkle, appearing on behalf of Mid-Minnesota Legal Aid and also on behalf of Legal Services Advocacy Project. I don't appear to be able to activate my camera for some reason.
Okay, well, we can hear you fine, Mr. Van Winkle, so thank you for speaking up. Sometimes our, the online, whatever it's called, it doesn't work that great lately. So apologies, that system is tricky. Well, Commissioner Tuma, why don't you start with questions, because you filed a decision option here.
Well, Madam Chair, and just starting from the parties, I was again trying, I think, capture what I saw in the briefing papers as something more than just issues related to low income. There's a lot of issues that are floating around. How do we enforce this new statute that's come up? And so I thought I was trying to expand a working task force to take into how we do this. Do we do it via tariff? Do we do it via rule? Do we do it via order? And how does our CIO fit into this whole role? How do we issue penalties? All those questions that come up. I don't want to lose sight of the fact that this is our full focus has been how do we get low-income folks to qualify for assistance. but it seemed to be a little bit broader. I also know there's a task force that was built into the statute, which I'm not trying to co-op, but there's just a lot of things we have to figure out, and so as much as that informs what we're doing, so I was looking to try to create a little broader new docket that explores all these issues, which in my mind would build off of you guys continuing to work together. So that was what I was trying to accomplish with option 5. I have no ownership to it at all, so if you think it needs to be improved, adjusted, or modified, please say so. But when I read the statute, there was still a lot of open questions. What do we do in this situation when a dispute arises? How does it articulate up to us? What is CAO's role? And so I think CIO would appreciate having conversations with you all too, to start, I guess, regulating landlords, who, by the way, I don't think is going to be as friendly as Xcel is going to be when they come in front of us, because they're not rate regulated by us. So I want to make sure we have a clear and careful understanding of how this works. So I'll just, Madam Chair, put it to the parties to say, do they like it, do they don't like it, and how they want to fix it if they.
Yeah, and I think, Commissioner Tuma, just from, the outside view of reading your alternative or your decision option, I want parties to be upfront with us on, like, they already feel like the implementation is set on a particular path. So I'm not saying I don't support your option, but I too want to just make sure we're helping to implement the new statute in a way that makes sense and is, I also will just say that, like, the legislature passed the change, and I want it to just start happening, not to be mucked up in, like, another stakeholder group. So there's a little bit of that coming out of me.
I worry about that too, Madam Chair. There was just a lot of, when I kind of read through the legalities of it and talked to our staff, there just seemed to be some holes in there that needed to be filled. So yeah, I don't want this to stop the implementation of the statute. If we have complaints brought in front of us, we should deal with them. But
So for the department, Mr. Teglin, why don't you begin, please?
Thank you, Chair Sieben, Commissioner Tuma. We're certainly not opposed to your recasting of decision option 5. One thing that we'd like to include is to make sure that broad participation among utilities is there, so that folks that may move between utility service territories can take those programs with them. We'd also like to draw attention to the list of topics that may be present in that docket in that work group.
For Xcel, Mr. Dennison.
Thank you, Chair, and thank you, Commissioner Tuma, for bringing your revised decision option. We looked at that and we felt there was merit in that. And to your point, though, Chair Sieben, we believe Xcel will need changes to its tariffs to address the new approach on shared metered residential buildings and to reflect the repeal of 504B.215 that is part of the legislation, has to do with de minimis usage and so it applies to, we currently have in our tariff specific citations to the now repealed statute. And so we'll need to align the two. So maybe if it is referred to a new docket, that the docket be bifurcated to first address what tariff changes needed from the utilities. And we believe that this unified, new docket is important. I would assume that we would have very similar language in all the utilities tariffs, as opposed to us coming in individually with our own versions of our tariffs and then trying to sort that out. So I think we need some structure here. And if that is understood to be part of the proposal here, that would, I think, be a productive path forward.
So then, Mr. Dennison, are you pulling back then from, like, decision option 2 and instead saying you want to discuss the tariff changes, or, like, just give a little more detail of what you want us you think is settled and should move forward?
Thank you. So we support decision options 1, 2, 4, and Commissioner Tuma's alternative decision option. The tariff changes reflected in decision option 2 are specific to CSGs, the opt-in, opt-out forms. And the other changes from new legislation are much larger. They're not restricted to CSG at all.
Okay, that's helpful. And Mr. Teglin, was that, before we hear from the other parties, was that your understanding of how this would work too and what you're supportive of?
Chair Sieben, yes, that's the department's understanding.
Okay, great. And Mr. Schultz?
Madam Chair, I think our position is correctly reflected in the briefing papers as 1, 2, 4, and 5. But we are supportive of Commissioner Tuma's alternative with perhaps a couple of caveats. I just want to so I agree with what we heard from Xcel that there is going to need to be a phase of updating utility tariffs to conform to the changes in the statute, and that's certainly within the Commission's jurisdiction. As far as enforcement of the landlord-tenant statute, that falls within our office's jurisdiction with respect to enforcing it against landlords. To the extent that landlords are not following the changes to Chapter 216B that the Commission has jurisdiction over, the enforcement authority for that is the Commission's authority over complaints. So customers would need to file complaints with the Commission. Complaints could also come through other agencies like us. And our thought on that is that maybe I agree with the chair that maybe we need some more experience with the statute, maybe at least a year before we really know how it's shaking out. So perhaps it makes sense to delay at least some of this, maybe not the changes to utility tariffs, but other aspects. And this could be left to the executive secretary's discretion on how to sequence it. But some of this isn't going to shake out for a while, and we're not going to understand how it's being complied with. One other point on the stakeholder group, I think those can be valuable. I think it's most valuable when all affected parties are participating, and in this case, that would probably include landlords, third-party billers, utilities, and the public interveners. Again, I think that makes sense to maybe delay that until for at least a year.
Delay the stakeholder group?
Sort of convening a stakeholder group. I think we're just not sure that most of this can't be accomplished through notice and comment, I guess. So perhaps in addition to Commissioner Tuma's decision option, C might be to add after convene a stakeholder group, if one is deemed necessary, and leave that to the executive secretary's discretion.
Yeah, I have no problem. I intentionally kind of made C a little bit more condensed because I wanted the executive secretary to exercise that authority to whether it's needed and when it's needed. And the other one who kind of said after the legislative session, and I thought, the executive secretary and Ms. McShane and all you guys can figure out, is this needed and when is it needed? That was my intent. So if we can work some language in there that supports that concept that we can deal with this in a normal course, I'm all for it. And also maybe even having some language that says this is not to delay any enforcement under the statute. That's not the intent at all. It's just to provide greater clarity for all of us as we step forward.
Yeah, and Madam Chair, to be clear, our office is supportive of stakeholder processes when they make sense, and I think most recently in this docket we haven't seen comments by some of those industry stakeholders, so it's just not clear. Maybe it would make sense to see how this statute shakes out for a year and then convene the broader group of stakeholders.
Mr. Shardlow?
Thank you, Madam Chair. We would be open to all the decision options. I think it's so many different issues bisect through this one docket. I think on the question of do we accept decision option 2 now, I think there are implications of statute that we understand today, and there are implications that we don't. And so, in my mind, decision option 2 is sort of the low-hanging fruit that is known, but that there would be value in a separate stakeholder group or docket that sort of delineates the broader questions that have come up about getting assistance to people in single-meter buildings and things like that.
Okay, and for Cub, please.
Thank you, Chair Sieben. Yes, we also support 1, 2, 4, and 5, or Commissioner Tuma's 5A. And I think I agree with things I've heard from everyone else who's spoken so far. On decision option 2, I do agree with Mr. Dennison that I think those tariff changes are more specific to where this problem intersects with community solar, and that's an Xcel specific program, whereas 5 is more exploring, what tariff changes and other actions might be needed, not just for Xcel, but other utilities as well to comply with that new law. So I do think it would be valuable to have a consolidated docket, as Mr. Dennison described, to take care of some of those technical changes to tariffs. And Chair Sieben, I appreciate your comments on the stakeholder group too. I do think those groups, of course, can be valuable, but I wouldn't want to see that slow down the more immediate implementation of any enforcement power there. I'll just also say I was a part of a few meetings around those legislative changes where it was really helpful to hear from and share information with some housing advocates that aren't always in front of the commission, but have more direct insight into how this might be coming up in the work they do with tenants. And of course, as others have said, having that participation from industry groups and third-party billers is, of course, important as well. So,
Mr. Edstrom, that was especially helpful for me, and just the way I was looking at this is we can move forward with the recommendations now that Xcel is proposing, and parties are supportive of it, but the new docket will take up sort of the second wave of what needs to be still worked on. And then obviously it needs to expand to the other utilities too that are encompassed in this. But I'm a little troubled by waiting a year to get the stakeholder group going though, because then what does that mean for Minnesota Power and Otter Tail, for example, or for other utilities that are impacted by the change? They'll just wait for the commission to make a decision on their tariff changes until the stakeholder group makes recommendations, or I don't know if anybody has thoughts on that. And I know it's not as much of an issue for the other utilities, but still seems kind of weird just to kick it off for that long for implementing the law.
Yeah, thanks, Chair Sieben. I guess my feeling on that is I do feel they could run in parallel, where I do think there are just more technical changes to the tariffs that can happen, and hopefully not be that challenging for the utilities to just identify where the new law changes how the law is referenced in their tariffs and work through that. And beginning some kind of conversation with a stakeholder group, I guess I don't have a problem with starting that sooner. I don't know what additional action for the commission might come out of that stakeholder group in the near term, but I suppose that's part of what would be discussed. So.
And then do we need other language saying that, and this is a question for maybe the department or the OAG, do we need other direction that the utilities that aren't Xcel need to file proposed tariff changes within a time frame, or do you want to wait for that to be kicked off into the stakeholder group? No offense, but it just seems a little clunky to, I don't know, if they can move forward and make the tariff changes that are explicit in law now, they should. I don't think we should like wait, but you guys are closer to this than I am, so.
Madam
Any
Chair,
thoughts?
Madam Chair, I agree we don't need to wait on the utilities making tariff changes to implement the statute, and the commission could kick that process off with a notice or something right away. I don't know about the legality of ordering other utilities to do something when they perhaps haven't been notified of this docket. It's an Xcel docket, but I think the commission could open that investigation docket right away and, ask utilities to explain how they're updating their tariffs to comply with the law, and do that right now.
Mr. Teglin?
Chair Sieben, the OAG's suggestion seems reasonable.
That we're waiting on the commission needs to tell the other utilities to do what the legislature told them to do. It's a little like, okay, we can do that now, but it's just, I'm getting a little frustrated, and not at anyone in particular, but it's.
Let me try to walk it. I think I got a solution, but so I would change C to read that delegate authority to the executive secretary to convene a stakeholder group if appropriate. And then it goes on, it says issue notices, set schedules, develop records, and designate comment periods and make recommendations to the commission. So what C does is says the executive secretary has authority to do a stakeholder group if it makes sense.
I think
But
that's.
then the rest of is important to note. This is not dependent on that stakeholder group. We will issue notices asking them to tell us what their tariffs are, whether they need any adjustments. That's what I assume the notice would do, and set a schedule for us to bring them in front of us.
Yeah.
So this is an Xcel docket. The new docket is going to be all regulated gas utilities, all regulated electric utilities, not munis and co-ops, but just the ones that are subject to the statute. And we'll get that information, and then through that, hopefully they'll make some changes themselves without having to be prompted by us. But in the end, it'll all come back to us in an appropriate docket. I would also add some language suggested by the Attorney General's office that the new docket is not meant to delay any statutory compliance or enforcement of the statute, so that
I think that's.
that's made very clear. We're still proceeding. If you violate the law as a landlord, you could be brought in front of us, or enforcement action under the statute could be brought for the OAG's office. So that's what I'm thinking.
Yeah, I think that's, it could be in a new docket, but we should need to have direction that our staff should then just notify the other, through notice and comment, like tell the other utilities what they need to do. It's not part of the stakeholder group.
Right, no, yeah, and that's what I'm trying to make very, we could even make the stakeholder group a whole separate, make it a D, okay? And so that the point is the focus, the central focus, and I see where you're going at, Madam Chair, is that the central focus should be getting the notices out there, getting information from these utilities so that they're enforcing the statute. If a stakeholder group is needed in that process, these folks can determine that working with the executive secretary. But that's not the focus. The focus is getting the information on how this is being enforced, what tariffs are out there, and that. So
We'll hear from Mr. Van Winkle, but I just want to say that I think we'll take a break and I'll talk to staff about a change to C.
Sure.
And then, because the way I'm thinking about it is we just tell the other utilities to file the tariffs to comply with the law. And then the stakeholders group would talk about other issues about implementation that are coming forward. And so it's kind of like we're getting things moving as the stakeholder group is going.
I think there's some value,
yeah,
there's some value in it's totally separating. I agree with you, Madam Chair.
Okay. So, can we hear from Mr. Van Winkle? But Xcel wanted to jump in, and then Mr. Van Winkle, I haven't forgotten about you. So go ahead, Mr. Dennison, if I said something wrong or you want to.
Thank you, Chair. No, just a point of clarification. So filing our tariffs requires a petition with the commission. So we can't just file our new tariffs. We have to ask for permission to file. And I take it that would be within this new docket. The utilities would file within the new docket.
I thought we were going to do decision option 2, and those are your tariff changes.
For CSGs.
Yes, the decision option 2 is specific to the opt-in and opt-out form for CSG subscriptions in the landlord-tenant context.
Oh, so it will be broader.
Yes.
Okay,
it's
got
a lot
it.
broader.
Okay.
Like shared metered residential buildings and who needs to be the customer of record, those type of issues.
So that's why Commissioner Tuma is always one step ahead of me, and he was talking about other tariff changes, and now I get it. Okay, Mr. Van Winkle.
Thank you, Madam Chair. Can you hear me okay?
Yes, we can.
Okay, good. I just want to make sure our technology is working on this end. Madam Chair and Commissioners, Legal Aid and Legal Services Advocacy Project also supports decision options 1, 2, 4, and 5, A and C.
Do you mean,
we also,
sorry to interject, Mr. Van Winkle, but do you mean, have you seen Commissioner Tuma's new A and C, 5A and C?
I have, and we appreciate and we actually are comfortable with Commissioner Tuma's A and C as well. I would only remark in that regard that the decision options A and C, to the extent that they refer back to the specific Department of Commerce non-exhaustive list bullet points, is a little bit more specific about energy assistance and actions to increase protections for customers, given the changes to chapter 107. Mm-hmm. So we are comfortable with Commissioner Tuma's recommendations, but we actually prefer options 5A and 5C in the decision options in the briefing papers because they're a little bit more specific. And if I could elaborate for just a second, the two sort of, thank you, the two kind of dangling issues, the big issues that we see at Legal Aid and the Legal Service Advocacy Project emerging from docket 21695 is the use of third-party billing and the potential problems or actual problems with access to utility assistance programs. And particularly when I discovered that, for example, the energy assistance discrepancy, which is generally speaking, and Mr. Shidlow can correct me if I misspeak, a much lower benefit, maybe $200 per season if you're not a named utility customer on an account versus perhaps $1,500 if you are a named consumer on a utility account. And of course, the CSG model contemplates consumers not being named on the account, at least in the case of submetering. So there's been some comments made about the implication of the new statutes, 216B, 022, 023, and 024, relative particularly to customer protections, consumer protections in the submetering space. We at Legal Aid are right now looking at, among our client population, the impacts of those statutes on the billing practices in the submetering space. And I agree with Mr. Schultz's comment that we're kind of in the information gathering stage to see how those statutes are going to work. But those are our concerns generally, are access to assistance, and particularly if it can be done, and I know this is a large ask, it's a tall ask, but if we can get more full benefit LIHEAP energy assistance recipients among the overall tenant population, not just those who are named consumers, that would be a huge step forward. I know that's a tall ask, but conceptually I'm thinking this would be part of the docket going forward. And at Legal Aid and at Legal Services Advocacy Project, we contemplated on these two issues, third-party billing generally and access to assistance, that once 21695 was closed, we would proceed to perhaps another docket that would more closely focus on these two issues. So we're hoping that the tariff submissions and developments can actually happen coextensively with the Commission's exercise of its authority and jurisdiction under the new statutes, and that the stakeholder group would not hold up that enforcement arm of the new statutes, and that these two things could proceed at the same time. Thank you, Madam Commissioner.
No, that was really helpful, Mr. Van Winkle, and I think gives a good basis for which we should think about moving this forward. And, you know, I also just want to call out and thank you and your organization who worked with other organizations here to pass the statute, because the commission is really supportive of getting assistance to all utility customers who are eligible for it. And so I think this is it is a little bit tricky to figure out how it's gonna work, but we wanna work cooperatively with everybody to ensure that that happens.
Yep.
And
Sure.
the staff just put like a recommendation in the chat for how to like kind of incorporate in what you said and into, can we put it on the screen? And then, and it's building off of this. So I just want to, but we can, if you want to go ahead while we're getting that up.
No, I just wanted to answer a question that was raised by Mr. Van Winkle about the original 5A, referring to the specific non-exclusive list of topics. The way I drafted A and B was, it was meant to incorporate that. It was not meant to exclude that. And so, I mean, the way I view my A and B is that it includes, but is not limited to, that exhaustive list that you put together. And because you're going to be part of the participants in the docket, I assume that list was not going to be lost. So I just want to be very clear. I was not into my intention with A and B trying to say, no, that list is not good. No, it's good, but there could be other things that come up. And that's
And
what
staff said they'd put it in the notice too.
Yeah.
They could include it. So that was a good point though, and thanks for clarifying that. I don't know if staff has the revised 5A. Everybody's reading it, me included, in real time, but we're attempting to like encapsulate all of the discussion here. We can take a break if people want to look at it and then see if they have any comments. And then, and allow time for Commissioner Tuma to talk to staff too.
it looks good, but my dyslexic brain always misses things like this at the fly, so.
Yeah, okay, why don't so if we can leave that up on the screen, and Mr. Van Winkle, you can see that, correct?
Yes, I can, Madam Commissioner. Thank you.
Okay, we'll take a short break and come back at 11:10 and then discuss this and anything else we need to. Commission stands in recess. The commission will come back from its recess, and first, Commissioner Tuma, I don't know if you had a chance to look at this and see if you're comfortable.
Yes,
and then we'll ask
I did, so everybody
parties.
knows there was just a minor change to 5B Romanet 2 that I asked staff to make sure it also said neither the opening of this docket or the stakeholder, nor the stakeholder group shall affect enforcement. I wanted it very clear that enforcement can still happen as we start to put together the tariffs. And, the statute is a statute, and that has authority, but I just want to make people think we're not going to wait for the stakeholder group nor the tariffs. If a complaint comes forward and it makes sense to the OAG's office, then it has to come in front of us. I read the statute was not, it was still not clear what comes in front of us and what doesn't and all that stuff. So we'll let you all figure that out, but we wanted to say we're ready and able and willing if you need to come in front of us to issue a penalty or whatever we need to do. So
Does anyone have any objections to this that they'd like to state? Mr. Van Winkle.
Thank you, Madam Chair. Commissioners, I've been looking at the new language in the alternatives, and let me just state what we understood at Legal Aid, or at least what I understood. I understood from the decision option, and I hope I'm not taking us back over ground that we've already discussed, and now I hope I'm not turning us around in circles. But decision option 5 in the staff briefing papers, with regard to assistance, we've got assistance and we've got third-party billing. Those are the two big areas. With regard to assistance, I had thought there was already a demonstration that we need to open a new docket assessing expanding low-income tenants' access to assistance, and that wouldn't be subject to a conditional if deemed appropriate, unless I'm misreading here. And as I said earlier, although with regard to the third-party billing issue, again, I agree with Mr. Schultz, we need to gather more information and present that to the commission and perhaps have another docket open on that subject itself if that appears appropriate. But I had thought the access to assistance was pretty much a given as a new docket, unless I'm misreading.
It's a good point. And I'm just looking to staff to see if what the thinking was in 5 about Mr. Van Winkle's point there, if we're not picking that up in the new revised 5A, or if we need to, or.
it was my understanding it was supposed to be broad enough, but I'm looking at this.
Ms.
This
McShane,
language for the first time.
is there already another docket that's open on exploring options for utilities to increase access to assistance programs for low-income tenants in metered buildings?
No, nothing specifically about master metered buildings.
Mr. Van Winkle, what am I not understanding then? You're saying that 5A, the language that's on the screen, should repeat that language and then, sorry, try again with me.
Madam Chair, I hope that I'm not the one who's misreading, but if you go 4 lines down to the new language, it says convene a stakeholder group if and when appropriate. And unless I'm misreading, and I may be, I thought that in the staff briefing papers, decision option 5 basically stated forthrightly that there's going to be a new docket open to explore assistance, expanding assistance to low-income tenants. So I saw that the assistance aspect as not conditional, as like that's going forward. And then perhaps other issues, including perhaps third-party billing, that's going to await more information. That's kind of what I thought. And so the language 4 lines down that says if and when appropriate, I'm wondering if that is where we're at with assistance, or we're going forward automatically on assistance.
No, I catch your drift now, and I think we'll fix it here, and I appreciate you bringing this to our attention, because the intention is to have a new docket where we do explore these issues. And And
Yeah, Madam Chair, that was my intent. That's why I had, my B was to call that out, that it was
Right.
intent to deal with those issues, so.
so if we removed if and, that might do it, but Ms. Gretz is working here too. Is yours off?
Make sure it's off.
This is an
I'm
exceptional.
getting an echo here, sorry.
Can you use Ms. McShane's mic?
Madam Chair, do you want a separate docket for the filing of the tariff? And then another docket for the low-income assistance? And then a third docket for the potential stakeholder group?
No.
I don't
Two
think so.
dockets, okay.
I thought that this docket would be open up, they would address, if needed, a working group, it would be, but they would address trying to make sure we get more people that are low income. That would be one of the focuses. I don't want to lose that focus. And we'd also address some of these other tariff issues in that.
So you're talking about two dockets, though?
No, just one.
Just one. So what if we said, what if we picked up the language from 5 as drafted by staff, where it says, open a new docket to explore options for all utilities to increase access to assistance programs for low-income tenants in master metered buildings that are rebuilt by a third party. And then pick up and just say, and explore options. Well, we're saying all utilities lot, and explore options. Essentially, we want one docket where those issues, all these issues are discussed, I think is what we're all trying to get to, right, Commissioner Tuma?
That was my thinking, as far as trying to get to.
Mr. Edstrom, if you could help us out, I'd appreciate it.
Thanks, Chair Sieben. I wonder if you could take staff's revised 5B and instead make that revised 5C of Tuma's alternative, and then keep the original Tuma alternative 5B.
Now my dyslexic brain is lost, so that's okay.
Now,
I like the fact that you like my drafting, but I don't know how it fits, so that's.
Did we take out the if and language there too? Does that help? Oh, no. I think if you say in revised 5B, Ms. Kaler, if you take out if and, that would help too, just to.
I thought there was some discussion about if it's not needed, we don't have to have a stakeholder group, but that's.
Well, then it says when appropriate, it will just be a long time from now. Or not appropriate.
Might not be appropriate, yeah. I suppose, yeah, that would be.
This is, drafting on the fly is not elegant here. Ms. Gretz, do you think that, do you know what we're doing? Let's take a break. Good idea. Okay, the commission will stand in recess until hopefully 11:30 or not much after that. Okay, we're in recess.
Sorry. Trying to make it easy, just made it harder.
the commission will come back from its recess and we'll hear from Ms. McShane first.
Hello. So the revised decision option 5 is on the screen. This would open one new docket about the tariff revisions related to the legislation. That's 5A. And in that same docket, we would also explore options for all the utilities to increase access to assistance programs for low-income tenants that are, rebuilt by a third party or landlords. Thank you. I don't think I have the right one. Okay. And then, okay, sorry, I misspoke.
Is this what's up there now in front of us? Is what you're looking at?
Yes, what's up there now is correct. So I'm going to restate this. 5A is just about the tariff changes related to the legislation. We left it open so that we could do separate dockets or all in one, subject to the executive secretary. 5B is a new docket just to do the stakeholder group for the assistance piece of it. And we said rebuild by a third party or landlords and didn't specify on master metered or sub-metered because that's an issue within the legislation. 5C is the delegation to the executive secretary and includes the language about the department's list of non-exhaustive topics. And then 5D is TUMA's suggestion about neither the docket nor the stakeholder group shall affect enforcement actions.
Okay, thank you, Ms. McShane. Since we're all just reading this in real time, who would like to begin to address whether you think this encapsulates the discussion we've had this morning? Or any concerns? Mr. Van Winkle.
Thank you, Madam Commissioner. Commissioners, I read this and was studying over the break the language that we had. It looks to me like this is all encompassing and is pretty comprehensive. And my take on it at this moment is that we would support it.
Okay, great. Anybody, Mr. Teglin for the department, does this look like something the department will be able to work with and help move the ball forward?
Thank you, Chair Sieben. I think this is viable. I think an improvement.
Your microphone isn't on. Sorry to interrupt. Oh,
Okay. Can you hear me now? Thank you, Chair Sieben.
It hears you now.
Okay. I think this list of revised decision options is viable. I think an improvement could be made to add the non-exhaustive list of topics identified in the department's supplemental comments into 5A to include in the comment period, so any tariffs that are proposed during that comment period would necessarily take note of that list.
Okay, so we can incorporate that change, and then also, I think at the beginning, sorry, I'm moving on to another topic, so what Mr. Teglin just said, Ms. Kaler, can you put that in somewhere? I don't know. And is that what you were getting at, Mr. Teglin, right there? Great. Then 5A, Ms. Kaler, if you could also add in authorize the executive secretary to designate comment periods. Staff said we just needed to do that for 5A to explicitly say that executive secretary can do that. Anybody else want to add anything? Otherwise, I think we're making progress, even though it's been a little tough. But we got it. Commissioner Tuma, thank you for getting us through this. Do you want to make a motion on the whole docket?
I'm happy to do that if you want. You can go ahead and do it too. It's
No, you've got it.
But I'll do decision option 1, 2, 4, and instead of the draft, everybody, new revisions 5A, 5B, C, and D, I believe, also.
Great. Am I supposed to be pausing, Mr. Shardlow, or you're good? If you think we're
I'm discerning if I'm good. I think I'm good. Yes, I'm good.
If you're not, you can tell us in the new docket.
Okay, thank you, everybody, including our staff, for working on this on the fly. All in favor of Commissioner Tuma's motion, please say aye.
Aye.
Opposed? The motion prevails. So thank you very much, everyone. There's no other business before us, so we are adjourned for the day.